Elizabeth, for those very kind words. The origin of this lecture is that just before I was contacted and asked if I'd be willing to kick off this new series of Northern Province lectures, I'd been in email correspondence with a group of people arising from something one of them had spotted in the Makin report. Towards the end of his report, Makin identifies a number of areas of church life that he says need addressing, and in relation to which he makes various recommendations. The first is the abuse of power. The second is deference, particularly in the context of Smythe, deference to his theological beliefs and his attempts to justify his abusive activity by reference to God and the scriptures in an aberrated way. And Makin goes on to say, quote, "The learning from this is that safeguarding should take prime place in the order of decision-making and actions to prevent abuse. Legislation, government guidance, and safeguarding policies within the Church of England take precedence over individual beliefs and church and canon law." Close quote. It seemed to me and others that in that passage there was a significant lack of clarity about the relationship between law, safeguarding, and people's opinions and beliefs that should be explored further. What I want to do this evening is to look at the concept of safeguarding in its widest sense and its relationship to the law. I must emphasise at the start of the lecture that all the views expressed tonight are my own and don't represent the views of the Society as such. I should also say at the start that this is a sensitive area. Statistically, there are very likely to be those among us who are victims and survivors of abuse, and I'm conscious that any talk of abuse can act as a trigger and can lead people to be traumatised afresh. So can we please have that in mind, especially when we come to questions and discussion at the end. The relationship between safeguarding and the law had hit the headlines prior to Makin, when the former Archbishop of York released a statement on the publication of the Lessons Learned Review into the case of the late Trevor de Manikin. As you'll no doubt recall, Lord Sentamu said towards the end of his written response, quote, "Safeguarding is very important, but it does not trump church law, which is part of the common law of England." Close quote. So where should we begin tonight? I think the obvious place is the concept of safeguarding. Safeguarding is hugely important in the Church of England today. It occupied a major part of the recent General Synod group of sessions. But the word safeguarding, as it's currently used, is very much of this 21st century. As some of you will know, I addressed the history of safeguarding in a previous lecture in January 2020. I don't intend to repeat that history now, but I do need to remind you of some of the headlines. Prior to the end of the 1990s, the phrase that was most commonly used for what we now refer to as safeguarding was child protection. From the 1960s, there had been a developing awareness of the reality of physical child abuse. What had until then been known to medical professionals and others as unexplained infant trauma syndrome began to be referred to as battered child syndrome. In 1973, in this country, the killing of Maria Colwell was the start for us of an understanding of the seriousness of that issue. And it was physical abuse that was the real focus of concern for the next 10 years or more. The Department of Health report on child abuse in 1982 examined the 18 inquiries that had looked into instances of abuse between 1973 and 1981. All were cases of physical abuse. A subsequent similar report was produced in 1991, looking at a further 20 inquiries between 1980 and 1989. In its introduction, it said, quote, "The mid-1980s saw an increase in the reporting of child abuse. It's not known whether or not the actual incidence of abuse has increased. Public awareness of child abuse has increased, and critical in this was the emergence of child sexual abuse as a problem which shocked, but possibly not surprised, the public." The word safeguarding does not appear in any of those reports. And that time frame, the 70s and 80s, also gives us context for the initial disclosures about John Smythe. In the 1980s, work done in the United States and published here about child sexual abuse raised awareness amongst professionals dealing with such cases. But it was in 1986 when Esther Ranson established the Childline telephone helpline that things began to take off. 1987 saw a lot of controversy in relation to the activities of a couple of doctors from Leeds who developed what they regarded as a technique for determining if children had been anally abused. The use of that in Teesside led to the Cleveland Inquiry, and that in itself led to the Children Act 1989. That was passed in November 1989 and came into force in 1991. It gave every child the right to protection from abuse and established the key principles which now govern the way decisions concerning the welfare and safety of children are made. The Act uses the word safeguard or safeguarding 10 times in the context of, quote, promoting or safeguarding a child's welfare. As I've indicated, the phrase is most commonly used in the 70s and 80s in relation to what we would now generically term safeguarding, with child abuse, child sexual abuse, protecting children, promoting children's safety and welfare, and keeping children safe. A document entitled Child Abuse Working Together for the Protection of Children had been issued as national guidance in draft form by the DHSS in May '86 and finalised in 1988. When a subsequent document was published in 1999, it was entitled Working Together to Safeguard Children. And since then, and in this century, safeguarding has become the generic word to deal with issues of protecting not only children, but also others who are vulnerable to abuse of one sort or another. Keeping people safe, or ensuring our churches are safe places, is clearly a laudable objective. And that's in the context of a society where in 2020, the Office for National Statistics reports that the Crime Survey for England and Wales estimated that 1 in 5 adults aged 18 to 74 had experienced some form of child abuse before the age of 16. That's 8.5 million people. And there's an estimated 3.1 million adults aged 18 to 74 had been victims of sexual abuse before the age of 16. And of course, we need to acknowledge the massive damage done within the church by those who should have been able to be trusted, but who abused that trust and did a huge amount of harm to many people. That 1986 Working Together document described itself as giving guidance. We'll see further subsequent documents speaking about guidance and recommendations. These are not hard law. The greater part of the material that has been issued by government about safeguarding is very much in what we would call the soft law category. What do I mean by referring to hard law and soft law? Hard law can be defined as law which is binding on everyone, represented in the UK by statutes and regulations, whereas soft law is comprised of guidance, recommendations, codes of practice and the like, which may be persuasive, but which is not legally binding. So firstly, hard law. In the secular world, in the UK, this is statute law, whether that be in Acts of Parliament or regulations, it's binding on all. Some of it is primary legislation enacted directly by Parliament. Some of it is secondary legislation, which is made by others who derive their authority to make those laws under some other piece of primary legislation. In the ecclesiastical world in England, it's often not recognised or remembered that the laws of the Church of England are part of UK statutory law. In times past, the laws governing the Church of England were made by Parliament, but more recently the Church has been given power to make its own laws. This goes back to the Church of England Assembly Powers Act 1919, often referred to as the Enabling Act. These primary laws passed by General Synod are now entitled measures. A measure can also, as in the secular world, enable the creation of secondary legislation in various ways. However, it's worth noting that all such primary and secondary legislation in the Church is approved by Parliament before coming into force. The canons of the Church of England until 1970 were made by the convocations of Canterbury and York. Since 1970, under the Synodical Government Measure 1969, the power to legislate by canon now lies with General Synod. It should also be noted that royal assent and licence are necessary before the making, executing and promulging of any canon. So the hard law nature of our canons is also very clear. And so to the extent that Makin and others set church law and canon law against government law, that is an inaccurate and unhelpful distinction. Measures, regulations and canons in relation to the church are in exactly the same category as acts of parliament and regulations in the secular world. Both are equally binding on all. In contrast to all that hard law, we also have soft law in both the secular and the ecclesiastical realms. That consists of guidance, recommendations, and other documents such as codes of practice, all of which set out what would be good practice, but they don't, in and of themselves, make that guidance binding. And quite a lot of current safeguarding material falls into this soft law category, although obviously there's some of it that's now mandatory, and we'll explore that shortly. However, safeguarding has no real meaning outside the hard and soft law, which either requires or recommends certain things to be done or not done. Keeping people safe is in part aspirational, in part intentional, and is a collective phrase that covers the contents of all those requirements and recommendations, but it doesn't really exist outside them as a freestanding thing on its own. If it isn't written in either the hard or the soft law, then it isn't really there in any meaningful way. And to that also we shall return. Well, how did safeguarding develop in the secular state? I've already referred to what happened in the late 80s, culminating in the Children Act, 1989. There were, however, continuing failures to protect children, not only in the church, but in many other agencies and institutions. In 1993, Safe from Harm, a Home Office document, was published with 13 guidelines about how to keep children safe. In 1999, the Department of Health published Working Together to Safeguard Children, which was subtitled A Guide to Interagency Working to Safeguard and Promote the Welfare of Children. As I said previously, the titles of the various secular world documents show they are about guidance and recommendations. They're not hard law. Well, how did the Church respond? In July 1995, the Church of England produced Policy on Child Abuse, and it set out how the Church would implement those 13 Home Office guidelines, which are set out in the appendix to the document. It saw the introduction of bishop representatives, quote, to advise and support him in his dealing with issues of child abuse, the beginning of the Diocesan Safeguarding Advisor. It's been noted that this was again all in the language of recommendations. A lot of work was done at this time in relation to other outworkings of the policy, some of which was incorporated in the next document, published in 1999, which was a policy on child protection. Some of the particular issues dealt with then were about voluntary declarations, because there was still no national or secular policy on the provision of criminal record checks. There was a lot more about good practice. In 2002, the Church of England appointed a lead bishop for safeguarding and a national child protection officer, a woman called Janet Hyde, who was the wife of the Bishop of Chichester. And the Church Central Safeguarding Liaison Group was created. In 2003, the first version of Guidelines for the Professional Conduct of Clergy was published, and it provided in paragraph 2.13 that every ordained person should have training in child protection. In 3.14, that a child or vulnerable adult who discloses abuse is to be taken seriously and referred to appropriate agencies. And in paragraph 7.2, it dealt with the seal of the confessional. 7.3, it says that, quote, where abuse of children or vulnerable adults is admitted in the context of confession, the priest should urge the person to report his or her behaviour to the police or social services, and should also make this a condition of absolution, or withhold absolution until this evidence of repentance has been demonstrated, close quote. In 2004, in February, the Church's third overall policy document was issued. This was entitled Protecting All God's Children, and it's described as the House of Bishops Child Protection Policy. It had greater status than the previous policies, as all dioceses and parishes were required to accept it as their key policy, although they could add to it. Paragraph 1.1 says, quote, "The House of Bishops will approve a handbook of good practice collated from the experience of dioceses and parishes. It's expected that future guidance from dioceses and parishes will be based on these documents." Close quote. Further steps were taken in relation to what are called diocesan safeguarding children advisors, and also people described as coordinators, to work with the incumbent and PCC to implement policies and procedures. They were the forerunners of parish safeguarding officers. But again, it's to be noted the emphasis is on expectation, good practice, and guidance. Appendix 6 is headed Managing Child Protection in the Diocese, a model of good practice. However, it says at 3.3 that all those who work with or in regular contact with such children must comply with this policy. It should be noted that this is a statement of expectation in a policy document. It still did not have the force of hard law. In 2006, the Church expanded its policy to include vulnerable adults in promoting a safe church. The parish coordinator became a bit more like PSO, quote, "It's recommended that a named individual be appointed by the PCC to act as the key person to speak on behalf of vulnerable people within the congregation and to outside bodies," close quote. In 2015, the professional guidelines for the clergy were revised, and in 2016, the Safeguarding and Clergy Discipline Measure 2016 was enacted. And in that measure, Section 5 imposed a duty on clergy, church wardens and PCCs to have due regard to guidance issued by the House of Bishops on matters relating to the safeguarding of children and vulnerable adults. And it made failure to comply with that duty a specific offence under Section 8 of the Clergy Discipline Measure 2003. Now, as members of the Ecclesiastical Law Society, you're people with some degree of legal understanding, and so you will have no difficulty comprehending the concept of due regard. Code of Practice to the CDM sets it out very well in paragraphs 38 and 39, where it says, where a person is subject to a duty to have due regard to guidance, the law requires that person to follow that guidance unless there are cogent reasons for not doing so. This does not mean that the person is free to choose whether or not to follow the guidance. Cogent reasons are ones that are clear, logical, and convincing. When applied, which will be rare, they must be based on case-specific advice from both the diocesan safeguarding advisor and the diocesan registrar. The disciplinary tribunal will scrutinise the reasons given with great care. The onus will be on the respondent to show that they had cogent reasons for not following the guidance. This was the first time that the Church really showed its teeth in relation to making any aspect of safeguarding a matter of hard law with consequences for breaking it. And it was also the beginning of the move away from the postcode lottery, much complained about by survivors, where different dioceses implemented the guidance in different ways. The background to that legislation is quite interesting. We're able to see the clear move away from soft to hard law, but also the recognition that not all guidance can be made a matter of hard law. In December 2011, Archbishop Rowan Williams appointed Bishop John Gladwin and his Honour Rupert Bursell as commissaries to undertake a visitation of the Diocese of Chichester to report on how safeguarding had operated or not operated in that diocese. They produced an interim report in August 2012 and a final report in May 2013. And that resulted in the Archbishop's Council bringing a paper to General Synod in July 2013, GS 1896, in which they rehearsed the matters and recommendations that were in the visitation report and the proposal to introduce legislation. Synod voted in favour of that, and so draft legislation was drawn up, which came back with an explanatory note, GS 1941, and that dealt with the various matters, but in particular, paragraph 48 speaks about the imposition of a duty on relevant persons to have due regard to the House of Bishops' current safeguarding policies. The paper also noted at paragraph 52 that it would not be practicable to impose a stricter duty than a duty to have due regard, because the safeguarding policies of the House cover a range of matters, including some that are good practice and advice, rather than being mandatory, and so there'd be problems in enforcing strictly those matters of good practice. The draft measure went through the revision process and came back for approval in February 2015, and final approval in July, eventually becoming the Safeguarding and Clergy Discipline Measure 2016. However, when in 2020 ICSA reported, it made a number of recommendations, including a number about the Clergy Discipline Measure. They were particularly critical of the due regard phraseology, considering it wasn't sufficiently clear. Their recommendations included recommendation 42, CDM needs to be reviewed in respect of how it manages allegations of child sexual abuse by clergy and how it treats complaints about a failure to have due regard to safeguarding guidance in responding to allegations of abuse. There are further 5 bullet points which were quite separate other recommendations. Draft legislation was drawn up to give effect to the recommendation and what were felt to be other necessary changes. The report of the steering committee, which presented the proposals to Synod in February 21, said in their report about the draft Safeguarding Code of Practice measure, paragraph 21, the draft measure is intended to give effect to the recommendation made by ICSA that the current duty to have due regard to guidance be replaced. And it said about the legal status of guidance to be contained in these codes that the House of Bishops would issue, paragraph 31 of GS-MIS 1271, the code may impose requirements on and give guidance to relevant persons. The relevant person must accordingly comply with the requirement imposed on that person by the code. The code will therefore not only impose requirements on a relevant person, but will also give guidance to relevant persons. And the relevant version is now contained in section 5A, subparagraph 3. The code may impose requirements on relevant persons and may give guidance to relevant persons. There are, of course, some earlier codes that the House of Bishops had issued which still fall under the due regard provisions. And there's a list of them there: conflicts of interest, responding well, safeguarding children, young people, vulnerable adults, religious communities, and safer recruitment. And until very recently, there were only 2 codes that were produced under the new provisions that had requirements, and that was Safeguarding Practice Reviews and the Safeguarding Learning and Development Framework. If you've done any safeguarding training in the last year or so, that will have been training that was under that last code of practice from the House of Bishops. But in February of this year, General Synod approved 2 further codes, which will come into force on the 1st of September this year. They are the Safeguarding Code of Practice Managing Allegations and the Safeguarding Code of Practice Religious Communities. The codes are becoming increasingly sophisticated. So the most recent one for managing allegations begins with a triage process. Is this a safeguarding matter, or should it be signposted elsewhere? If it's safeguarding, is it about a church officer? And if so, should it be sent to the NST or referred elsewhere, including a serious incident report to the Charity Commission? And then it sets out the process for safeguarding case management groups with different pathways for clergy, volunteers and others. But particularly interesting is pathway 4F, which is for people who fail to follow guidance as against those who perpetrated some form of direct abuse. In these cases, the SCMG becomes a safeguarding code of practice meeting with a view to developing a safeguarding development plan. Other sections on risk assessments and closing cases, including with resolutions and apologies. Now, the practice in both the older due regard codes and the newer requirement codes is the use of blue boxes. Wording in the blue box is something to which due regard should have been had or something which relevant persons are now required to do. Everything else that's not in a blue box is at the level of guidance or good practice, or as it said, quote, why and how to deliver the requirements. So the position is that historically, safeguarding advice and guidance has simply been that, advice and guidance. The first time there was hard law involved was 2016, and when due regard came into force. Prior to 2016, of course, someone might be criticised for not following the guidance, and that will be a factor taken into account in any CDM proceedings, and it would be quite possible for the cleric to mount a defence for failure to follow guidance by saying there were other factors that needed to be taken into account as well. And that, of course, was the position in 2013, when the complainant in the Jane Humphreys Lessons Learned Review was in communication with a number of people, including Archbishop Sentamu, to which we'll return. It was also the position in 2010, when the Right Reverend Stephen Cottrell became Bishop of Chelmsford and inherited the position where the Reverend David Tudor was in post, and also when he became a canon of the cathedral in 2015. Various suggestions have been made, particularly on social media, as to what should have been done to remove Tudor from office. But they don't grapple with some of the complexities that follow from the alleged perpetrators of abuse being licensed clerics in the established church. Not only do we have the case of Tudor, we also have that of Hindley at Blackburn Cathedral, who not only had a freehold post, but was also resident within the parish of a parish church cathedral, and so had a common law right to attend services. So we need to address next the position of those who are ordained into the ministry of the Church of England, and who hold various positions after being so ordained. The first matter is that of holy orders, and that's a matter of canon law, hard law, and the canons provide in Canon C1 how someone becomes ordained to holy orders, and make clear that once so ordained, although the ordained person may voluntarily relinquish the exercise of their order by a legal process, they cannot otherwise be divested of their order other than by being deprived of the exercise of their order or deposed from their order, in each case by a legal and canonical process. However, once ordained a deacon or priest, they are not free to come and go ministering wherever and whenever they please. Where and how they minister is also directed by canon law. Canon C8 provides that a minister duly ordained as a priest or deacon may officiate in any place only after he or she has received authority to do so from the diocesan bishop in which that place is situated. Under Canon C8.3, the diocesan bishop confers such authority on the minister, either by instituting the minister to a benefice, whether by virtue of freehold or common tenure, admitting the minister to serve within the diocese by licence under hand and seal, or by giving the minister written permission to officiate within the diocese. As you will know, the position of clergy is that clergy are principally office holders. Holding office is different from being in holy orders, but you can't hold an office without having been ordained to one of the orders. And those referred to in the first two bullet points about benefice clergy and clergy licensed under seal cannot be deprived of their office apart from through a lawful and canonical process. And currently that's either the clergy discipline measure or capability procedures under the Ecclesiastical Offices in Terms of Service Regulations 2009, but they're very rarely used because of their complexity. As compared with benefice clergy and unbeneficed clergy who hold a bishop's license, there are those who hold the bishop's written permission to officiate, PTO. Whereas a license cannot be withdrawn or cancelled except by legal and canonical process, a written PTO is now governed by the House of Bishops policy, and it can be revoked summarily, thereby depriving the cleric of any ability lawfully to exercise ministry, and therefore any other diocese. Paragraph 6 of those PTO regulations provides 6.2, the diocesan bishop is not expressly required to give a reason for withdrawing PTO, though it should not be done without good reason. In 6.3, there's no right of appeal against the withdrawal or refusal of PTO, but the cleric should be given an opportunity to put the case for why PTO shall be continued, granted, or renewed. All the above is part of the law of the Church of England, which is part of the hard law of the land. It's enforceable not only in ecclesiastical courts and tribunals, but also where relevant in the secular courts as well. In the light of these issues around the removal of clergy not proved to have been guilty of something for which they can be prohibited or removed, the previous consideration as to whether clergy should be made employees has been revisited. That suggestion initially arose in 2002 when the Department of Trade and Industry issued a discussion document as to whether Section 23 employment rights under the Employment Relations Act 1999 should be granted to clergy. The direct question then was not whether clergy and others should become employees, but whether they should have access to many of the rights enjoyed by employees, in particular the right to make a claim to an employment tribunal for unfair dismissal. A synod group led by Professor David McLean looked into the matter and produced various reports in stages for General Synod. The report at the second stage looked back at the first stage and said about that, paragraph 11, "We gave much time to question whether clergy should become employees and reflected on the particular relationship between the bishop and his clergy. We concluded that the employer's entitlement and also opportunity to control the work of an employee, if necessary on a day-to-day basis, was alien to the relationship between a bishop and his clergy. Largely for this reason, we ultimately rejected the idea of making clergy employees and recommended that the office holder status should be retained through the medium of common tenure by means of church legislation." At paragraph 19, they reflected on the responses they'd received to that first stage report, saying the general tenor of the discussions and comments was one welcoming our approach and of widespread support for the main features of our proposals: granting of Section 23 rights, continuous of office holder status, the notion of common tenure, and the introduction of a capability procedure. And so the current situation came about, with the introduction of common tenure and a capability process, amongst other things. This may again become a live issue if the Charity Commission pick up on it as an impediment to safeguarding. One other very recent development has been the passing of the Clergy Conduct Measure 2025, which in about a year or so will replace the CDM. One of the features of the CCM is the express relationship to safeguarding professionals. Consequently, in the near future, they will become parties when a case involves safeguarding features. And it's also intended that safeguarding professionals will move their concerns into the discipline process much more quickly than has hitherto been the case. Consequences of a finding of serious misconduct will include the possibility of prohibition and the withdrawal or revocation of a licence. Such a finding of serious misconduct will, for now at any rate, remain the only effective way of removing from ministry someone such as Tudor or Hindley, who has common tenure or who holds a bishop's licence. The requirement that a case against a respondent is proved on the balance of probabilities will continue. Insofar as the authors of various reviews of safeguarding cases are concerned, in many cases the lead author is leading a multidisciplinary team, they sometimes refer to any finding of fact they make as being based on the balance of probabilities. That's another phrase well understood by those of us who are lawyers. But I quite doubt it is always understood by those who conduct these reviews. In English criminal law, the standard of proof is so that the fact finder is sure that guilt has been established. The phrase "beyond reasonable doubt," much loved by scriptwriters and the wider public, has not been used in the criminal court other than to disclaim it for many years. However, the standard of proof in civil cases is the balance of probabilities, which means it must be established that something is more likely than not to be the case. But how is that balance achieved? The answer is by weighing the evidence on each side and asking which is more likely to be the case. But that exercise requires there to be some evidence to place in the scales. If there's no evidence about something, then there's nothing to place in the scale, and the exercise can't be carried out. To apply that to what Macon says about Justin Welby's knowledge of Smythe being an abuser, he says in his report at 16.10, he did know of John Smythe, and on balance did have reason to have some concerns about him, but that's not the same as suspecting John Smythe had committed severe abuses. Based on this evidence, it's not possible to establish whether Justin Welby knew of the severity of the abuses in the UK prior to 2013. To say it's not possible to say whether is an unfortunate way of expressing it. there's no evidence at all to suggest he did know. So there's no way of positing that he might have done that, other than by groundless speculation. From an early stage, there's been the recognition that when things have been seen to go wrong, the Church needs to know why it happened, what might have been done to prevent it happening, and what might be done differently in the future. There was a well-established pattern in the secular world of holding serious case reviews. Those were the types of review drawn together in those Department of Health reports of 1982 and 1991, to which I referred early on in this lecture. The Church has, in so many other aspects of this subject, replicated what the secular world did. And so they were commissioned a number of what were initially described as independent reports. I think the very first one was the one often referred to as the Carmi report, which I had the privilege of chairing a multidisciplinary group for. And interestingly, Edith Carmi was a very well-qualified social worker in London, and she obviously knew Janet Hind, who was the wife of the Bishop of Chichester, who wanted to have something, and he got her along to suggest she might do something, and she said, well, you need to do what we do in the secular world, and so we had the multidisciplinary group which guided her and oversaw her as she did her inquiries and eventually produced the report. That was commissioned in 2001, reported in 2004, but it wasn't made public until 2014. And that was the report about Terence Banks, a steward at Chichester Cathedral. Quite a number, though by no means all of the other early reports, were also into matters that had occurred in the Diocese of Chichester. We should note in particular Roger Meekings into Roy Cotton and Colin Pritchard, January 2009. Dame Elizabeth Butler Sloss, again into Cotton and Pritchard, commissioned in 2011. The Bursell Gladwin Visitation of 2012, final report 2013. Judge Carhill into Dean Robert Waddington in 2014. Ian Elliott into Garth Moore 2016. Dame Maura Gibb into Bishop Peter Ball in 2017. And Alex Carlisle KC into Bishop George Bell in 2017. By 2017, the phrase lessons learnt case reviews was often being used in relation to this type of review. And that was the phrase formally adopted in the 2017 practice guidance, known as Responding to, Assessing and Managing Safeguarding Concerns or Allegations Against Church Officers. Paragraph 9.2, it says, once all matters relating to the safeguarding concern or allegation against a church officer have been completed, the core group should consider how best to identify and learn lessons from the case. There's detailed guidance about how the review should be set up and undertaken, and to whom any outcomes should be made known. Lessons learnt reviews were commissioned under that practice guidance. They include the one by Judge Pearl into Bishop Whitsey, by Jane Humphreys into Trevor de Manicum, and the one by Keith Makin into John Smythe. They all fell within the 2017 practice guidance. And one of the key principles in that guidance is said to be, the case review should be conducted in a way that recognises the complexity of circumstances in which people and organisations work, seeks to understand who did what and the underlying reasons that led to individuals and organisations to act as they did, and seeks to understand practice from the viewpoint of the individuals and organisations at the time, rather than using hindsight. I've added the emphasis in that quote. In July 2023, Synod approved this new code of practice in relation to safeguarding practice reviews, so we're now SPRs rather than LLRs. And this goes into much greater detail about the process, as would be expected in a dedicated code. In the General Synod explanatory material provided with the draft code, there was set out what was described as a three-step process. Step 1 is identifying and managing the risk through the core group process. Step 2 is focusing on responsibility and accountability and includes the making of CDM complaints. And the third process, learning lessons, is about taking a step back to try to understand why the events happened in the way they did and what were any underlying organisational and contextual issues which contributed to them. Answering the why questions enables an organisation to learn and make improvements that will keep people safe in the future. Without these underlying issues being identified and addressed, there remains a risk that unsafe practice and organisational factors continue. And importantly, it underlined that, quote, Safeguarding practice reviews are not judicial processes designed to establish guilt. If people think they are, they will inevitably be disappointed and frustrated. Therefore, it's important to prevent that by providing absolute clarity about their purpose, close quote. And that's repeated in the code itself in section 1.2. Some more recent reports are those of Fiona Scolding, KC, into Sole Survivor, and Sarah Wilkinson into the creation, work and termination of the ISB. What's clear in all this history, and has become clearer as time has developed, is that these LLRs or SPRs are about learning lessons with recommendations being made as to future practice, and are not about attributing responsibility or delivering accountability. So the most recent iteration of the guidance spells out, if people think they are about establishing guilt, they will inevitably be disappointed and frustrated. Sadly, it's clear that many victims and survivors do look at these LLRs with that hope and even expectation, particularly if for whatever reason they've not been able to lay such guilt on their abusers through other parts of the process. Against that background, I'd like just for a few moments to look again at the Humphreys Review and the role of the former Archbishop of York. Terms of reference for that review are set out in the report, and they're very clearly to consider people's actions or inactions against the standards of practice which applied at the relevant time rather than using hindsight. From what it appears, she was told by the Archbishop that he was dealing with a survivor, having been put on the Archbishop's list as a result of resigning after a CDM complaint was lodged against him, as is provided for in section 38(1)(d) of the Clergy Discipline Measure. The fact that the President of Tribunals became involved suggests this was a contested matter. It was also clear that the Archbishop was provided with legal advice by his provincial registrar in accordance with the well-established practice at the time, to the effect he must not compromise his judicial role in that matter by getting involved at other levels. Consequently, he did no more than acknowledge the letter. In the review, the reviewer makes no findings about what the standards of practice were at the time, and therefore makes no assessment of his behaviour against such standards. That can be contrasted with an earlier review by the National Safeguarding Team in March 2018, which they didn't deal specifically with the judicial independence point, but more generally said the Archbishop had followed the relevant practices of the time. And what the reviewer goes on to say is that, quote, no church law excuses responsibility of individuals to act on matters of a safeguarding nature. She then goes on to say what she would have done without any reference to any contemporary standards of practice. So she's talking about what safeguarding as an abstract concept, without reference to any soft law policies or guidance, let alone any hard law requirements, requires. She says what as a safeguarding professional she thinks requires to be done, but without any chapter or verse as an authority as to why the Archbishop should have done that in his circumstances. Sad as it is, this afternoon I was reading through the principles of common law common to churches of the Anglican Communion. And at the very end of that booklet, there's a little article by the Bishop of Lesotho, Vicencia Kagabi, and she says that she remembers very much being told by somebody not so very long ago that the church is governed by law and not by whimsy, and that's for her become something of a mantra. And that brings us full circle to where we started. Safeguarding is not a thing to be contrasted with law, whether secular or ecclesiastical. Safeguarding is simply how we keep people safe so that we can worship together, work together, and thrive. We do that in part by prevention, in part by intervention. In part it's done by obeying what is mandatory for all, and in part it's done by following guidance which you do as best you can, often balancing out various factors. We have over 30 years moved from only having guidance, which did allow for a postcode lottery, to one that now clearly identifies what is required practice. What is very unclear in Professor Jay's recent report about the future of safeguarding in the Church of England is that she's very unclear about the time frame of the many issues she says people were complaining about, particularly in relation to postcode lotteries. And there's very little evidence of what the timescale is for the things that people have said to her. But we do now have the evidence from Inequi, who are carrying out the current safeguarding audits in all dioceses and cathedrals, and who stated in the press release accompanying their annual report published in February that, quote, "Our findings highlight a positive trajectory reflecting improved safeguarding practices led by diocesan safeguarding teams. These teams comprise individuals with significant experience of working with statutory agencies and other relevant organisations, ensuring a robust and informed approach to safeguarding within church settings." Of course, there are important decisions that still have to be made about the structure of operational safeguarding. But I hope that we've seen tonight how matters have developed over 30 years, and how now there is a national set of enforceable requirements which bishops and others would only ignore at their peril. We now have in place proper systems for dealing with matters that emerge, whether they're of recent or non-recent origin. But we need to acknowledge that nothing will take away the pain of those who were abused and or whose abuse, when it was disclosed, was mishandled in the past.